very challenging. I think I can see that.
Can I also add something more
Yeah.
to that? Because the fact that once you have entered the national field in India, under Section 59, you can make amendments, but those amendments have to be within the scope of claims which are originally filed. So what has been filed in the PCT and the PCT application at the PC stage enters India, and what gets amended has to be within the scope. So what is in the specification is lost forever.
Yeah.
You can't get it at all because that's an additional hurdle along with the fact that you can't get the specification, but the fact that under Section 59 of the Indian Patent Act, there's a further restriction.
Yeah.
So that's to add to your point.
Yeah, that is really, I can see that is an issue, the challenge faced especially by multinational companies, the big companies. Yeah. So any other comments on this topic? If not, we can move to the next one. So the next one is Chicha mentioned, and nowadays we try to really speed up the prosecution process. And it used to be you have 12 months after you receive a first examination report, and now action, or like a FEA. And now they give you like 6 months, and then you can extend it for another 3 months. And I see this is kind of a welcome. I think intent probably is good, but the problem is the rule doesn't say anything about the examiner's response. It doesn't say they can take maybe 6 months to respond, or 2 months to respond, or 3 months, or 1 year to respond. So I want to ask the panel, how can we make this rule? What changes from a patent office you expect to see to make this rule actually work to the benefit of the patent applicants? Yeah, go ahead.
So what we're finding here, I guess some of the discussions that we're picking up, is the Patent Office is making some changes, and in making those changes, because a lot of times they're going through it for the first time in a very long time that they're changing the Patent Act, the workings of the Patent Act, they're missing some steps. When the rubber hits the road, we're realizing that they're missing some steps. Okay? Now, one thing that I'm really, in dealing with the Patent Office, and I think other people here can agree with me, the Patent Office is very flexible. They're very approachable here in India. Okay? We can, as an industry, if we want to, reach out to the Patent Office and explain to them what our concerns are. And they're very willing to listen, okay? I think that's one thing that, as an industry, we should be doing, is not just talking about it among ourselves, but working together in some industry body or individually and reaching out to the Patent Office, Rajiv Agarwal or whoever, and saying, here's some of the concerns that we have, and here's why we have those concerns. Because I think in my previous dealings with them, they're very responsive, and they're very willing to work to see if there's a real problem, to resolve it, and move it forward. Because at the end of the day, and something we'll talk about a little later, the national IPR policy, at the end of the day, the government, I feel, really wants this to work, wants IP to be respected, and is willing to work with industry to make that happen. So I don't know how other people's reactions have been or opinions.
Thank you. Oh, you're going to go? Okay. So in fact, I think this should be a welcome change, because I believe the logic is that the backlog at the patent office should be reduced, and if that's the logic, then I think this is a step which has been taken in the right direction. But as you rightly said, this has to be balanced. The responsibility cannot lie only on the applicant. There has to be a sharing of responsibility also by the patent office, and if there's a deadline also to the examiner that this has to be cleared within the particular time, then I think it should really work out well. And I believe that the number of examiners are being increased, and there are a lot of initiatives taken by the government. So other than the fact that the Project Patent Council, who's handling the application from some other part of the world, find it very difficult to comply with this timeline because he has to look at different jurisdictions and then ensure that the proper response is given. But if the applicant is ready to take the effort, then and if it is also supported by the patent office, then I think it should really be helpful.
For me, I agree with what Vipin has been saying. There is the need for improvement and this to put things together where we are really improved. That I can see in everyone who is involved with IP. So the many reasons like why we are having these discussions is also like stemming from we do want to see this improvement, and there would be steps taken to have the corrections in place. Last few years, there's so many positive communications coming from government and patent offices to work it out. So several meetings and things like that. But for me, I don't see the solution lying in starting to specify each and every item. Like you should do this, you should do that. So the solution will not come when we start looking into those things. Intent is strong. We start with something. Of course, we have to like trust the other parties are also taking whatever steps required to gear up and complete like their role. So if there is a timeline that has come, okay, we look in 6 months, then I would like assume that with the different steps that has been taken to reinforce the examination thing, there are certainly steps to see that from the patent office side also the turnaround is fast, because that is what has stemmed to all these changes that is happening. So the pendency issue should disappear in a few years' time, or should become like whatever the reasonable number and not so high as what we are having now. So it's a step in right direction, and results are also seen, like the number of examination reports that are coming in like month by month, and they have like increased. So overall I see a good improvement happening here.
Yeah. I just add a couple of things from personal experience is that I've had my complaints about the patent office in the past, but the last few months I've seen a dramatic change in the way they're handling our applications. Their rates are very fast, they're very proactive, they make themselves available, and we couldn't ask for more. And our people go for the hearings and they come back, and we have a good conversion rate, and there's nothing to complain. And we've done some searches about checking about how are they going to speed up and what is going to be the process. So we hear that each examiner has a target around 15 or 17 per month. So that means around 2 applications they need to process in a day approximately. But if you start calculating on the pendency versus how many examiners have been recruited versus when they will be able to accomplish this, we did some calculation in our office, and I think by May or June 2018 or something, they should have been cleared. Ideally, I'm saying so. Maybe in 2 to 3 years' time, we would be over there. I really hope that the speed will continue and they will continue to be as responsive. But I see a lot of change in the way they're doing it and feel very positive about it. Yeah.
Thank you. There's a lot of things to talk about, but we are running out of time now. So, but before we leave this topic, I do want to bring up another feature. It's about accelerated examination. When I read that rules, accelerated examination, you have to use Indian Patent Office as a search authority, or use Indian Patent Office as IPEA. And this, I think, works very well probably for Indian company, but it doesn't work very well for international company. For example, if we have a company, let's say in Europe, in Germany, and the inventors are in Germany, we file it, we cannot come here to the Indian to file, and because we don't have a resident applicant here, right? And then we have to file in EPO. In EPO doesn't accept like India as probably, I don't know, maybe this is the wrong example. Let's just assume EPO doesn't have an option to choose Indian Patent Office as a search authority, and then you're stuck. You cannot use this accelerated application. So I think for this rule, to me, it's not very balanced. It's kind of a balanced toward the domestic company. So maybe someone else, let's just have only one comment here, and then we move to the next topic.
Yeah, no, I fully agree with you. We've come across this already, because I always ask the team, can we accelerate? And was explained the rule. And it's difficult to find the right balance between all the countries to accelerate, because every country have their own regulations. So harmonization there and being in line with what other countries do would help here, definitely, yeah.
Yeah. No, I have an update on that for you because I've been following this up very closely. So as of last week, what we've been told is that when you say express, it will be filed along with the application the day the national phase entry happens. I'm not really clear about how this will be taken care of, and does express also mean expedited? I don't have clarity on that, but hopefully it means a little faster than normal.
Okay, let's move to the next topic. And next topic is about injunction, temporary injunction. And as kind of, I think most of people have heard, India now becomes, it's very easy. Compared to many other jurisdictions, it's pretty easy to get a preliminary injunction, or called temporary injunction here. And so I want to hear just what your view on this. To me, it's almost seems like it's way too easy for a patent like owner to get a temporary injunction. And patent is pretty complicated stuff. It's a technology, right? It's not that easy to prove it's actually there is some kind of infringement or very high likelihood of infringement. But to issue a preliminary injunction so quickly and with such a high rate, to me, there's something here we need to discuss. So let's open it to the panel.
Maybe then I think from the farmer side, I could just add to it, because I don't necessarily agree that ex parte injunctions are given quickly, because probably the basis of your analysis has been only from one court, and that's the Delhi High Court. If you look at the different courts in other parts of the country, the ex parte injunctions are not so common. So if you look at Delhi itself, yes, there have been some injunctions in this year itself, and but a few years back this was not the case. So to come to this point of getting injunctions quite early has been a task, at least for the pharma industry. And in fact, there have been situations wherein we know that we should be getting injunctions ex parte, but sometimes the courts are not willing because they are not sure about the validity. And then, so I do not necessarily agree with that comment that ex parte injunctions are so common. It's only in one part of the country that you're looking at, and not in the entire country. So,
but what I hear is almost 80% of patent cases is basically concentrated in Delhi High Court. Is that correct?
well, that's because if you get injunction from one court, the applicant is the patentee is confident that he'll get it from over there and not from other parts of the country. If you get more examples of early injunction from the Bombay High Court or from Madras, probably there'll be more cases filed in those jurisdictions. Because it's not, and that's probably the reason why we see only one part of the analysis over here. That's my view over here.
Okay, well, I'm not sure of the rates of injunctions or whatever in India. I had heard it as well, that it was, the standard was quite easy to get preliminary injunctions in India. Obviously coming from the US, that's kind of blows my mind, because obviously it's extremely hard to get a preliminary injunction in a patent case in the US, because, I mean, basically you have to prove that more likely than not you're going to win the case. And so basically what are you going to do? You're going to put up your case at the beginning trying to get a preliminary injunction. As you know, I was in patent litigation for nearly 20 years now, and it's just as an in-house counsel, it's a hard call to make that you're going to actually, you know, pay for all that work to try to get a preliminary injunction, which probably is not going to work at all, especially now after eBay, looking at injunctions. So, I mean, I think in that light, getting, an injunction, a preliminary injunction is just kind of, especially on a major case, it seems quite blowing my mind. But especially in a high-tech case, right? Because there's hundreds of thousands of patents in a lot of high-tech products. And so you're allowing basically one patent owner to stop basically practice of all the other patents in that product and halting innovation in that product. And that kind of, in my view, would give a windfall to this person to get especially a preliminary injunction, because can they really prove beyond, I'm not sure the standard is beyond a shadow of doubt, but are they, in the U.S. it's more likely than not you're going to win on all the claims of your patent so that you have a right to have that, and then you're going to now stop basically innovation on that patent because they're not going to be able to sell that product anymore. It seems a bit harsh, actually, for me, and it just seems that when you do that, how do you justify that? Because it seems like, at least in India, I'm told that the cases go on for a very long time. So you get a preliminary injunction. I don't even know if you get to the damages phase of the case, because how many people even last that long? I mean, I'm told that, well, in the U.S. you guys have problems, you have outrageous damages. Yes, I completely agree. But at least we get to that part of the case. I don't know if you can get to that part here if you've got the preliminary injunctions going forward. So it seems a bit heavy-handed in my view, of course, coming from my perspective of there's other things in these products. How can you just preliminarily stop this product in the marketplace? That's one aspect, obviously.
I'd like to take a different approach to that again.
Go ahead.
In my opinion, the Indian marketplace and the judicial system and the approach to IP is at a different stage in its life cycle than it is in the U.S. In India, the amount of the amount of products, innovative products that are out in the marketplace that are not put there by the inventor, in other words, that are put there by somebody else, is phenomenal, okay? It's a tidal wave, okay? The amount that the inventor actually puts there is a very small percentage. And so if you want to create a positive environment for intellectual property and give some strength to the patent owner, you need to give them a very strong weapon initially. And I think that's what the government has effectively done, is saying, we're not going to touch this. We're going to let the courts slowly evolve case law to develop what should be a positive approach to injunctions, preemptive injunctions, and so on. And so initially, at the very beginning, at the start of the race, it's wide open, it's very easy to get. And as Raul pointed out, as different courts in different cities want to get the IP cases coming to them, like Texas in the US and some other cases in other states, they will have very easy laws and easy hurdles to jump over. But those cases will eventually move up to the Supreme Court. There will be case law set, and then it'll get settled. It will take time. There will be many importers, legitimate importers, and other members, other patent holders that are in the product that will get hurt along the way. But I'm not sure, is there another way that we can help improve respect for IP and then balance it? Because if we have, sorry, one more thing, if we have the government come in and say, here's the standard that we want, we're going to have the same argument at a higher level or at a different level. So I'm very happy that we're letting the courts decide what the case law should be, and the waves will go back and forth, but I think they will eventually settle to something that the country can handle.
Right, but so I guess the question from my perspective, just because I'm not an Indian lawyer, is, but doesn't that hurt innovation? How many people can have the stamina to withhold that, I mean, to go through the preliminary, almost automatic injunction at the preliminary stage, and then last as a company to kind of put things forward? Or, for example, why, I guess for us, Americans, I guess, I can talk about myself, we love money, right? So we love big damages awards. So why wouldn't money be something that would substitute for the injunction as the remedy then?
So I guess now we're going to talk about U.S. law. So I mean, in the U.S. also, up till 2001, if I use patent trolls, and I feel I can use that term, having worked for one of the companies that was very effective as a patent troll, as a patent licensee, sorry. Patent holders were able to ask for injunctions as long as they had the patent and whether the patent was really tested or not. I mean, the big case you're probably aware of is BlackBerry versus NTP, okay, where NTP was saying, Mr. Rim, you're violating our patents, please pay up, and otherwise we're going to ask for the judge to file an injunction, and until they got their $600 and something million, they were threatening that. And after that, the U.S. has very quickly recognized that that is not the way to go, and they've started pulling back and now not allowing injunctions and where damages can suffice if you're not practicing. We're not at that stage yet. We have still, I mean, the U.S. probably took 50, 60 years to get to that stage. We still need a few more years to get there. So I think we're moving quickly, but we need to recognize that damages are not as big in India as they are in the U.S. That's the first point. Secondly, even if they are, small players in India are very, very resourceful. You have, I mean, some of the big cases right now that are in front of the courts. Ericsson against Micromax, against Intex. I mean, these are very big companies that are challenging, at that time when they first came out, very small startups in India and asking them to stop. But the company said, no, we're not going to stop. We will pay money into the court, and they're paying crores of rupees into the court to keep the case going. And they're finding ways to keep going. So I think there is some, it's not as big of a hammer, it is a big hammer and to hit a little fly, but I'm not sure if there's another way. The little flies somehow are very resilient and able to whiz around that hammer and still survive. So that's where I'm not sure how else you can work on that.
Well, you know, though, I would say that an injunction is actually, it is a damage. It's like 100% of your profits, right? Because you instantly stop. So it is actually a damage. And I would say, though, on the analysis, though, do you, and I don't know, again, I don't practice here, do you feel like that as a defendant going into a patent case, that you're really getting your case heard on the merits of the case, on your prima facie case, on your, you know, is the patent valid and infringed? Because it just seems, I guess, from your perspective, you know, for that, on a preliminary injunction, you've got to basically hit the nail on the head on that. You've got to win on all points. You know, you've got to have a solid case for that. And it seems like the perspective is, and I don't know if it might be an invalid perspective, is that it's, in India, you don't get that, you don't get your day in court on all those aspects. It's kind of just preliminarily like swept under the, you know, oh, well, plaintiff has a patent, therefore it must be valid and infringed. Let's move on to preliminary injunction. That's at least the perspective that it looks like from our side. So that would be like, well, gosh, you know, aren't we scared to be in India, kind of thing.
So,
Yeah,
and
I have just a
okay.
perspective on this. So I don't have much experience with patent injunction, but a couple of cases when we had infringers infringing our trademark and design, we got the injunction pretty fast. And no damages at this stage, but we could stop them on the day one with the court order saying that please stop now because we have a court order. I think that helped us a lot. If you look at it from that perspective, I think it's very welcome also for the consumers because they don't end up with counterfeit products. They end up with the genuine products, so I would support it. Of course, it was not easy. We had to have the case for this, but I'm supportive of this. So long as there's a content, there's a reason for asking for the injunction.
Okay. You have some comments?
Thank you so much for allowing me to talk in between. Trademarks and copyrights, I completely agree with you. But the same principles cannot be applied to patents. If we look at the data points, some of the data points show that if between 2005 and 2015, if we analyze the cases, in more than 60% of the cases, preliminary injunctions were granted, and many of this were ex parte injunctions, which were granted on day one, day two, right? And if you look at the permanent injunctions, in more than 69% of the cases, permanent injunctions were not granted. These are two contradictory views. So you're granting temporary injunction and then you're not granting permanent injunction means that there is something which is not closely looked at while granting temporary injunctions. And what I'm trying to say is we have a responsibility to look at that before granting temporary injunctions. Definitely, patents should be valued. There has to be a lot of respect for patents, but it should not be at the cost of affecting somebody. There has to be a balance in the system. That's all I want.
Yes. I just want to add one more point. In India, we actually don't have a presumption of a patent's validity, right? In India, yeah. So, and here, but when we grant a preliminary injunction, we pretty much kind of doing the reverse. We kind of think most patents is valid. In reality, like there's some kind of a report saying for all those ACP patents litigated, in the end, only 12% is actually end up with valid. So there's a majority of them is not valid patents. So I think I can understand what Vipin is saying, but I think probably India is kind of going to another pole a little bit too far.
Yeah.
So I think it's, SK, you want to say something?
Yeah, RPX made a study on this. Only 12% of the patents, I'm just repeating what you said, only 12% of the ACPs were found to be valid. These were litigated cases. And there is also another analysis which says that around 36% of the 3G patents are valid, right? And there is one more study which says that only 45% of 4G patents are valid. So in any case, less than 50% of the patents are valid, and we are granting temporary injunctions assuming that the patent is valid, which needs to be looked at very closely, right? Granting a temporary injunction and expiring injunction based on a higher percentage of higher probability of a patent being invalid, it doesn't seem to be very right.
Okay, so let's have.
I think it shows that it all boils down to quality again. If the quality of examination process is really at a high level and the quality of the enforcement actions and the people deciding is also at a high level, then I think nobody should have a problem with decisions like this, because as indicated by Vipen, there is really a need to have injunctions and to develop also with that the IP culture more. But if the quality is not enough, then I think people will start to be afraid and doubt and be concerned. But if quality is high, I think there should be no issue with the system.
So I think we're really running out of time. I'm gonna have to cut off a little bit here. So let's move to the last very important topic, which is a national IPR policy. Last year, India published a very welcoming national IPR policy. And I think I originally prepared quite a few questions, but we have only like 13 minutes left here. So I'm gonna just summarize here. And I see there's a three features. It basically want to increase awareness of IP, which is really welcoming, really good move. And also it's to encourage commercialize the IP or securitize IP. And overall, I see some comments, people saying this IPR policy overall benefits the foreign right owners. I want to ask the panelists here, do you agree with these comments? They basically say this IPR policy overall benefits the foreigners, basically, foreign IPR holders, yeah.
I just have one comment, because the policy by itself doesn't articulate a lot of points. I think it will be interesting to see, because they talk about a lot of things, including improving enforcement and advocacy and a lot of things which are very forward-looking, but until it translates into a proper document, we would not have much to say. It's just a wish list right now, and we'll see how it evolves.
I had not had this impression or even this question when it came. Like for me, it's a bit surprising, because I never, at no point in time or in any of my past discussions also come across such a comment on this. The impression that I have is the national IP